Hello, my name is Rachel Mirapol, and I'm a senior staff attorney at the Center for Constitutional Rights. I will be speaking with you today about limitations and opportunities for people in federal jail or prison to sue officials for money damages for violations of their constitutional rights. 42 U.S.C. Section 1983 allows for an individual to sue a state official for money damages when that individual has violated the Constitution. There's no statutory counterpart for people who are harmed by actions by federal officials. And yet, there are thousands of people on any given day held in Bureau of Prisons facilities, in federal immigration detention, and in federal jails. These people face all the same problems as state prisoners. They may face abusive guards, inadequate health care, violence, and restrictive conditions. So litigation is just as essential a tool for these individuals. There are three main ways to address abuse in these federal contexts. The first is a claim for injunctive relief. Here there is very little difference between the usual injunctive cases brought on behalf of state prisoners and individuals who are in federal custody. If you are dealing with immigration detention, however, you need to be aware that the Eighth Amendment does not apply to detainees. So conditions claims brought on behalf of immigration detainees or other federal detainees will be brought under substantive due process, based on the standard the Supreme Court explained in Bell v. Wolfish in 1979, which is that detainees may not be punished, and courts may infer punishment from punitive or restrictive conditions that are not reasonably related to a legitimate goal, if they are arbitrary or purposeless. The second main mechanism is a claim under the Federal Tort Claims Act, or the FTCA. This is a federal statute that waives U.S. sovereign immunity for certain torts by law enforcement officers. It's extremely useful for incarcerated people, with the limitation that it can only be used to address torts, not necessarily constitutional violations. And it does not result in damages from the offending individual, but rather from the United States, which means that it may not deter continuing illegal action. Third is what's known as a Bidens action. And this is an area of the law that has changed significantly in the past 10 years, and it is where we will focus today. The Bidens Doctrine started with the Bidens case itself, where the Supreme Court implied a private cause of action for damages under the Fourth Amendment based on an unreasonable search and seizure. Two more Bidens cases followed. Davis v. Passman in 1979 allowed damage claims for gender discrimination under the Fifth Amendment. And, most important for prison practitioners, Carlson v. Green in 1980 allowed the family of a deceased prisoner to seek damages from Bureau of Prisons officials, including the head of the Bureau of Prisons, for deliberate indifference to a serious medical need under the Eighth Amendment. During the 80s and the 90s, it seemed like the Bidens Doctrine would expand to basically become a counterpart to Section 1983 cases. Over the next few decades, almost no federal courts considered whether they were expanding Bidens and whether such expansion was appropriate when they allowed prisoner constitutional claims under the Eighth Amendment, the First Amendment, and the Fifth Amendment. Now, one exception was prison cases involving private prisons. In Correctional Services Corporation v. Malesko in 2001, the Supreme Court declined to extend a Bidens remedy to a prisoner who was seeking damages from the corporation who was running a private prison. And in Minichi v. Pollard in 2012, the court denied a Bidens action to a prisoner who sought damages from an individual private prison employee. Now, these two cases are frequently talked about as a narrowing of the Bidens Doctrine. But it might not be fair to really consider these cases a narrowing because in some ways, a ruling allowing either of the two claims to go forward could be seen as a major expansion of Bidens. From the first time it was created, Bidens was meant to provide a cause of action against an individual federal officer to disincentivize future constitutional violations. And as the court has repeated, it is not meant to change an entity's policy. Malesko, allowing a claim against a private prison itself, could have been seen as a pretty big change. And Minichi, while maybe could be more easily seen as a narrowing, truly did not involve an individual federal officer, the way other successful Bivens claims did. Now that said, the tide didn't really start to turn against Bivens cases until Ziegler v. Abbasi.